Phil Weiser is the Attorney General for the state of Colorado, and he's also running to be the next governor of Colorado. And he has been going toe-to-toe with the Trump administration. More than 45 lawsuits and counting since Trump took office in January of this year. But it's not just defending the rule of law. It's not just fighting back against the Trump administration. Phil Weiser has also focused his gubernatorial campaign on affordability, public safety, the environment, civil rights, the things that all of us deserve and that we're struggling to have under this particular regime. I had the chance to sit down with Attorney General Phil Weiser to talk about some of the litigation that he's doing and to also explore his background a little bit and why it makes him the next best governor for the state of Colorado. And joining me now, I have the privilege of being able to spend some time with the Attorney General for the state of Colorado, Phil Weiser, who is also running to be the next governor of that great state. Attorney General, it's good to see you. How are you doing today?
Doing great, Katie. Great to be with you.
Now, listen, you have definitely been on our radar for a long time. I want to kind of take a short trip down memory lane, if you don't mind humoring me a little bit. One of the kind of bigger high profile things you had to deal with in the last few years was when the state of Colorado had some challenges as to whether or not Donald Trump was even able to appear on the ballot to run for president of the United States. The Secretary of State, Jenna Griswold, was somebody who was involved in that litigation. It was definitely something that you were backing as well in terms of supporting the idea that Donald Trump should not have been eligible to even appear on the ballot. We know what the Supreme Court of the United States did with that. In fact, you and I, when the news broke of that SCOTUS opinion, went live together. I think I was filling in for my good friend Ari Melber at the time. Thoughts about where things have evolved since then? You clerked for Ruth Bader Ginsburg. I'm not sure if people know that, but I think it's very important for them to know. And you've served as the Attorney General for Colorado. You're involved in multiple lawsuits against the Trump administration. Did you ever think, Phil, that we would end up in 2025, at the end of 2025, where we are in terms of where we used to be?
Katie, there's so much to the moment we're in that is jaw-dropping, that is mind-blowing, and that is hard for all of us. I want to pick a few of the threads and pull them through. Please. First, the role of the state of Colorado in that litigation was an important one, and sadly, it could still be relevant. Colorado has the following legal position. It's the one that we argued at the Supreme Court. If someone is ineligible to be on the ballot, the state of Colorado says they shouldn't be listed on the ballot. Let me give you a very clear case. If President Trump were to run for a third term, we've heard a lot about this. My position in Colorado is he doesn't get to be on the ballot. That case would end up going before the Supreme Court because Colorado law is clear. If someone is ineligible, if they're too young to serve, they don't get to be on the ballot. We have to make sure we honor the rule of law in our Constitution. And part of what's so, again, hard to grapple with is these basic constitutional principles. The commitment to the rule of law itself, it is in the balance. And at this term at the Supreme Court, there are a number of crucial cases. And you mentioned my late great mentor, RBG. She'd be turning over in her grave, even that we're asking, if you're born here in the U.S., are you guaranteed citizenship in the 14th Amendment? That's been decided for over a century. It's now back at the Supreme Court. Can the president essentially take the position that tariffs can be created, changed, and the law requires there to be an emergency, a justification? Well, this president hasn't bothered with that at all. And will the Supreme Court make sure that the rule of law holds? We're going to see. This is a crucial time for our republic. To your point, I believe in the rule of law. I believe that we live in a democratic republic. And as Ben Franklin famously said, we have a republic as long as we can keep it. It's up to all of us to make sure we keep our republic.
So, Attorney General, I wanted to stay on this issue of Trump versus Anderson for just a second. That was the case that ended up in front of SCOTUS, because I'm sure it was incredibly frustrating to go through all of the kind of remarkable evidentiary findings that we had from the state of Colorado that Donald Trump himself incited an insurrection that took place on January 6th of 2021. That makes Colorado unique in terms of those evidentiary findings. And then to be told that the states are given deference for how they run their elections. But then the Supreme Court says, nope, sorry, Colorado, Congress is actually the ultimate arbiter of who ends up being on these ballots. It kind of had to be just kind of cheats Coloradans, don't you think, of their ability to be able to govern themselves? And it kind of flies in the face of small government. But I just curious how you felt about that.
Katie, I got to go back to January 6th and just recall how horrific, unprecedented, and scary that day was.
Sure.
Jason Crow from Colorado knew his life was on the line. People were out to kill Mike Pence, Nancy Pelosi, and others. And political violence in this country is on the rise. Obviously, January 6th is a particularly horrific day signifying that threat. We have to condemn that threat. And the violence that day was urged by the president, whose quote, I believe it was, when he was told by the Speaker of the House, please say something, Mike Pence's life is in danger. The president refused to say anything. And Congress had the chance to impeach Donald Trump for what I believe is as problematic an action we've ever seen a president do, seek to undermine the peaceful transition of power, seek to encourage a riot that was harming law enforcement officers. Congress had that opportunity. It was before the Senate. Mitch McConnell will, I believe, live to regret, maybe he already does, that he didn't do what history, I believe, called for in that moment, which is to say that conduct is so disqualifying, we shouldn't allow this person to occupy the Oval Office. That's what I wish had happened. Obviously, it didn't happen. And what Mitch McConnell said at the time was there's a criminal process that will hold President Trump to account. And then, as we know, we didn't see that process get started. The January 6th committee started, and that should have been a bipartisan committee, just like Iran-Contra was bipartisan. This was a threat to our basic system of governance. It called for a commitment to preserve government of the people, by the people, for the people. Only a few brave souls, obviously Liz Cheney among them, were willing to break party lines to do what was right for the republic. And finally, there was an effort when a special prosecutor was appointed to investigate crimes. And we've now come full circle. President Trump is once again in the White House, and he pardoned everyone who committed those crimes on January 6th. Some of those people are out there committing additional crimes. Law enforcement officers have died because of what happened on January 6th. We have to take seriously this principle. The rule of law depends that we will fully and faithfully enforce the law. And just to add more insult onto this injury, qualified, dedicated members of the FBI, of the Department of Justice, were fired simply because they did their job investigating crimes that happened on January 6th. And now we're seeing pardons being given out like candy because people are well connected and can pay a bunch of money to somehow get the right people to push them forward. That's not what our system of justice was designed to be. If you look at the Supreme Court, it says equal justice under law. Whoever you are, political party, rich or poor, you get treated fairly under the law. That's what the rule of law means. That's what we have to uphold.
And that's what you've been doing as the Attorney General for Colorado. You don't just talk the talk, you're walking this walk. You are now leading a myriad lawsuits, at least 40 of last count vis-a-vis this particular administration, to defend Coloradans specifically. You are making sure that certain basic constitutional rights like birthright citizenship, et cetera, that those are respected, but that the separation of powers is something that is also respected. More than 40 lawsuits in county that you have been a part of. I had a two-part question for you. One, how critical is it the role of Democratic attorneys general? I have had the chance of speaking with some of your colleagues, running the gamut from Rob Bonta to Matt Plotkin to others, William Tong. You guys are all really kind of the vanguard. You guys are the ones that have really kind of been leading the charge to defend Americans, your constituents, but like Americans, I think at large. And then number two, how important is it then to take that energy and translate that into being the governor? Because we've seen governors now that have to be the vanguard, right? They're the ones that have to stand in the breach and defend their citizens of their states against an unruly, unlawful, and disrespectful and incredibly cruel administration.
Katie, you might think about this moment as calling for fighters. And the question is, do we have fighters or do we have folders? Do we have people who stand for the principles of our Constitution and of America? Or do you have people who are willing to accommodate and try to make nice? In my race for governor, obviously I bring my 45 lawsuits and counting, my commitment to fighting for what's right and being clear about standing for our values. And I'm running against someone, Senator Michael Bennet, who voted for more of Trump's cabinet than almost any Democrat in the Senate. And as you're shaking your head, that's exactly the right response. We don't need people who are pushing an agenda that says, well, let's try to build positive relationships with people. Maybe they're going to be okay. You can't normalize this behavior. There was nothing normal about January 6th. There's nothing normal about Project 2025, about ending birthright citizenship, about breaking the law right and left. We need moral clarity. And you've seen governors, J.B. Pritzker comes to mind, who are very clear. We're not letting a federalized National Guard come to our state. We're not going to allow the mistreatment of the LGBTQ community. We're going to make sure that we defend the rule of law and we do what's right. And that's something that attorneys general and governors need to be clear on. It should be bipartisan, just like the review of what happened on January 6th should be bipartisan. This is about the basic principle you said. We live under a government of laws. We cannot live under the whim of whoever happens to be president who thinks that their executive orders are law. Executive orders are not law. The Constitution is the ultimate law. And you made a very important point about separation of powers. A lot of our lawsuits are because there's law that Congress passes and the president says, I'm going to disregard that law and withhold money, for example, and punish Colorado. That's not the way our system works. I'm fighting for Colorado. We're in court and we're winning.
And I was also pleased to see that several of the pillars of your campaign to be governor aren't just focused on fighting back against the Trump administration. You're also focused on affordability for Coloradans. You're focused on public safety and the environment. I mean, these are things that it's funny because I just saw a headline and this is a great segue to this question to you. The headline was from an Axios piece from just maybe like yesterday or something. And the headline was the following, Attorney General. It was, quote, in Colorado, progressives challenge establishment Democrats for party's future. Your take on that headline, you think it's accurate? Would you label yourself as being a progressive, or is it more the policies that you're advocating for?
One of the important distinctions right now is, are you a grassroots fighter? Are you standing up against this lawless bullying administration, or are you going along? Are you someone who tries to accommodate or make nice? And I will tell you that distinction is crucial. I know who I'm fighting for, the people of Colorado, and I'm not afraid to take on anyone. To your point, I've taken on this president 45 times, often on issues that are pocketbook issues for people here in Colorado. The tariffs are obviously a big example. People are paying more because of these illegal tariffs. Another issue is I challenged a grocery store merger between Kroger and Albertsons that was going to raise people's prices for food, that was going to hurt local farmers, that was going to hurt workers. And I took on these billion-dollar companies because I heard from the people of Colorado. We did 19 town halls across Colorado. We went to court. We helped stop that merger. I've been taking on RealPage, setting prices for tenants who are paying in Denver over $130 more a month because of this collusion that is happening using this algorithm that RealPage is sharing private information between companies who should be competing, not colluding. Coloradans want a fighter. They want someone who puts them first, who's not afraid to take on anybody. That's how I've been operating as Attorney General. That's how I'll operate as governor.
What about moving the space headquarters? Like, that's wild. And that's direct retaliatory, retributive conduct from this administration because they're mad. They're mad that you guys won't share voter roll data, which is compromising personal and confidential information. They as in the Trump administration, they're pissed that you guys are fighting back when they're trying to take the space headquarters away from Colorado Springs because they're mad, because they don't like that you're not playing ball.
Katie, you raised a great example there of why we need a governor who knows the law, who's committed to the principles of our Constitution and is not afraid to fight for them. Because there are people in Colorado today, even some Democrats, who say, can't you just try to make nice and say nice things? Maybe they'll throw us some crumbs. I disagree completely. When you're up against a bully, you don't take their punishment. You don't let them take your lunch money. you punch them in the nose and say, I'm not going to be treated this way. And in this case, this is what was said to Colorado. I don't like your mail-in voting system, which the president said was automatically crooked. That's a lie. We have a safe, secure, national model of voting. It's a gold standard. We're not going to change it because the president threatens and tries to bully us. In fact, the authority to set our voting system is ours in the Constitution. And when the president tries to take away our authority, tries to undermine our sovereignty, my answer is I'm going to fight for it. That's why I'm in court by myself in this case, fighting against administration who's trying to punish Colorado, who's trying to intimidate Colorado. As Attorney General, as Governor, I won't be intimidated. I'm going to fight back.
You know, I was struck by something when I was preparing to speak with you that about which I was unaware, that your mother was born in a concentration camp. And Phil, when I read that, I was floored. Just by the sheer depth of the atrocity of what your mother and your families had to go through. The fact that you're a first generation American, you know, you're a child of immigrants as well, right? Like this is something that resonates, I know, a lot with you when it comes to the administration trying to come after our friends, our families, our community members, the people that we go to school with, that we work alongside, that we worship and pray with, right? They are being targeted. And Colorado specifically, is always attacked for, you know, being a quote sanctuary city, right? For being able to just be decent about people's human rights. But I read about your background and I had to ask you, you know, we have been talking about, and I'm unabashed about this, you know, we really are seeing past being prologue, right? We are seeing echoes of fascism and 1930s Germany. I just did a piece recently because I went to Amsterdam and my family went to the Anne Frank house in Amsterdam. I mean, these are things that are stark and yet terrifying because, to your point, people are rolling over and they're being appeasers and they're not standing up to fight for the basic civil and human rights that we all deserve.
Let me share a few thoughts and thank you for giving me a chance to talk about my family story. America is a nation of immigrants. E pluribus unum is our model. Out of many, we are one. I'm proud of a Colorado story of Ralph Carr, a great governor of our state who during World War II refused to put Japanese Americans in internment camps and who said, Japanese Americans are welcome in Colorado. You are a citizen. We will protect you. That is a tradition that I believe in. And I don't know that we're going to get through this period easily, but I believe we're going to get through it because I believe in the America that welcomed my family here as refugees who'd survived the Holocaust. We often talk about the concept of calling someone an other, whether it's a Jew, someone who's Japanese American, someone who's gay, someone who's black, someone who's Muslim. And here's the honest truth. Any attacks on people based on who they are, rising hate against people, it doesn't stop with one group. It's very important. And I give a yearly talk commemorating a Baba Yar massacre where I really take some time to think about what it means to see rising hate in society. And what I have come to, we have to treat hate against any group as hate against all of us. Because had that happened, people would have acted sooner and we could have and we would have saved lives. We need to make sure that we're not harming lives, whether it's people who are immigrants or LGBTQ community or others at a time when the America that I know and love is on the line. And that's why, yes, for me, this is very personal. And that's why the American dream is personal for me because my family, we came here with nothing. And I've had the opportunity to become a lawyer and work for Justice Ruth Bader Ginsburg, to work for President Barack Obama in the White House, to be Attorney General, and to be Colorado's next governor, all in one generation. That's the America that we're fighting for, where no matter who you are, you can achieve your dreams.
It's pretty spectacular, right? If you just stop and you think about how far you've come and how far your family have come. How can people find out more information about your campaign? How can they support you? I have noticed, Phil, that even when I am talking about races that may be specific to certain jurisdictions, there is a national response. People really care about what's happening across the country. If there's one silver lining that's coming from a particularly chaotic and bad year under this administration, is that I do think people have been finding a sense of unity and coming together to help each other. So how can they help you?
Thank you, Katie. You know, a saying that is personal to me, comes from my faith, is you don't have the obligation to complete the work of repairing our world, but you're not free to desist from doing your part. And so your call to everyone who's part of this community, we all have a part to play. And I would encourage people, please adopt races for leaders who are going to represent our values, even outside where you may live, because we're all in this together. And we need states and leaders at the state level to make sure we're creating the type of state that, whether it's abortion rights, whether it's equality for the LGBTQ community, how we treat immigrants, how we take on climate, and so much more, that our values are being advanced. Learn more about my values, my vision at philforcolorado.com. You can share the information you can learn. Obviously, you can donate there. You can tell others you know in Colorado about our campaign. You can volunteer from afar, and you can also buy merch. Whatever works for you, however you want to lean in, we need your help. We welcome your help. Thank you for getting engaged. I often say our Democratic Republic is not a spectator sport. It's a team sport. We need everybody in the field.
That is right. I just recently interviewed Pastor David Black from Chicago, who was shot in the head with pepper balls by ICE. And he said, democracy is not a spectator sport. You are 100% right about that. Attorney General Phil Weiser, who is on track to be the next governor of the great state of Colorado. It has been an honor to spend time with you. I am inspired, as always, by the work you're doing. And thank you for carrying the torch for so many and for leading the charge to defend all of us across the United States, not just for those that are in Colorado.
Thank you. It's an honor to serve.
Katie, breaking news out of the Fifth Circuit Court of Appeals. This appellate court holding that Donald Trump's invocation of the AEA, the Alien Enemies Act, to justify the summarily rounding up and deportation of certain individuals off of American soil is not allowed. This is a huge opinion. Why? Because this is the first time that we're really getting an interpretation of the Alien Enemies Act when it comes to certain defined terms within that statute. And as we've noted here on this channel, this constant flow of information about whether or not Trump has appropriately alleged an emergency or whether or not he's appropriately doing what he's supposed to do. I mean, it's overwhelming, right? So when we get the clarity of a decision like this, when it comes to something as important as the AEA, which really kind of got the whole, I want to say, outrageous immigration ball rolling at the beginning of Trump's term, I think it's important for us to cover it. Look, this is not even the entirety of the opinion. The opinion is 100 and some change pages long. This is the majority. I want to walk through it very quickly with you because I just thought it was too important not to share it with you. To refresh your recollection, because I know there's been a lot of cases here, this case began after 2 of the 3 petitioners who are natives of Venezuela were detained by immigration officials on the basis that they were allegedly members of the Venezuelan gang Tren de Aragua. TDA is what we're going to call it, right? So what happened was those petitioners, they filed for a writ of habeas corpus in federal court. We've talked about habeas corpus here. It's this idea to bring the body, meaning bring the body before the court to have to explain why is that person being held and whether it's legal for that person to be held in custody or detention. Those petitioners filed a writ of habeas corpus alleging that they were about to be removed to El Salvador, to CCOT, under the terms of Trump's March 2025 proclamation invoking the AEA. They wanted an opportunity to dispute, to deny that they were members of Tren de Aragua, and they needed to have the chance to be able to do this. I mean, that is the due process that they were seeking, right? So they moved for something called a temporary restraining order, meaning they wanted the district court, the trial court, to block the government from being able to remove them off of U.S. soil while their habeas corpus petition was pending. It actually fast-tracked to the United States Supreme Court. The United States Supreme Court granted A temporary injunction, meaning it said, okay, temporarily, we're going to block the United States government from removing any of you, and we're going to remand, meaning we're going to send this back to the Fifth Circuit Court of Appeals with specific instructions for that appellate court to do a certain kind of analysis and exploration of the facts. You still with me? Okay. So here's the thing. This is a 3-judge panel in the Fifth Circuit Court of Appeals. Okay? So these 3 judges came to this conclusion together on this issue. Now, let's talk about the following, because I want to kind of very quickly walk you through some of the precedent about the AEA, because there's really not a lot of it. And so this is another very big case. So this is a 3-judge panel, and it was a 2-to-1 decision. And let me tell you, the Fifth Circuit is very conservative. So this is a big win for immigration advocates. But here we go. So there really isn't a lot of Supreme Court precedent or authority to look at concerning the AEA. Why? Because that damn thing is from 1798. And according to this opinion, there's only been pretty much 3 times that the question has been posed in terms of whether or not the statute is applicable. And it's amazing, right? Because if you read it, it says here, the first and only time that the court is needed to analyze the statute prior to the 2025 presidential proclamation arose 150 years after the statute was enacted. So I want to stop for a second. So it's enacted in 1798, and then it takes 150 years for it ever to be kind of looked at by the court, right? So it's the same question that was posed in 3 cases. Did World War II and the president's authority under the Alien Enemies Act end, right? So in the first 2 instances, the answer was no, and the third time it was yes. But let's really quickly kind of walk through those 3 instances because they're very relevant for your consideration. Why? Because each of those 3 instances, the Supreme Court held that there is the opportunity for judicial review of interpretation of that 1798 statute, meaning that unlike what President Trump and his lawyers was trying to say, that there is no review available for him because as the executive, he's allowed to look at this Alien Enemies Act and he's allowed to use the statute and make his own declarations vis-a-vis, whether there is a need to be able to invoke the AEA. Well, the court's like, no. The Supreme Court has allowed the judicial branch to be able to conduct its interpretation and review. So here is the checks and balances that we talk about in basic civics happening right now in this decision. And I loved this language. I thought it was important to share with you on page 4. The court says judicial humility is particularly appropriate here. Our analysis leads us to grant the preliminary injunction to prevent removal because we find that there is no invasion or predatory incursion, and that we believe that currently, based upon what the updated notice has been provided to immigrants by the government, that it's actually satisfying due process. And we're actually now going to take this case and we're going to send it back to the trial court for further work that needs to be done. We declare, as did the Supreme Court, that our injunction solely applies to the use of the war-related federal statute, the AEA, and it does not impede use of any other statutory authority to remove foreign terrorists. And this was really important, right? Because the court wanted to make clear that if immigration agencies want to travel under other appropriate statutes, whether they deal with terrorists or not, this court isn't binding the federal government's hands. This is only dealing with the invocation of the Alien Enemies Act of 1798. So very thoughtfully and in detail, the majority goes through the definition of the AEA, which I'm going to read to you again, just to refresh your recollection, and then kind of goes through the really detailed historical analysis of this statute. But again, to refresh your recollection, adopted in 1798, the Alien Enemies Act, the AEA, authorizes the removal of natives, citizens, denizens, or subjects of the hostile nation if there is a declared war with a foreign nation or government, or a nation or government is engaged in an invasion or predatory incursion of territory of the United States. And as we've noted, Trump invoked the AEA to remove Venezuelan nationals who he claimed were members of the Tren de Aragua, the TDA, which is a designated foreign terrorist organization. Alrighty? So, once this analysis was begun by the appellate court,
This is what the court said. All the parties agree that as a precondition to invoking the AEA, there must either be a declared war, an invasion, or a predatory incursion by a foreign nation or government. Everybody agreed that there is no declared war. Why? Because Congress has not declared that there's a war. So you can kind of check that box off, right? So what are the remaining two areas that this appellate court had to evaluate and look at? Well, they had to look at, is there an invasion? Is there a predatory incursion that would justify Trump using the AEA in order to have that immigration roundup that is being done? And the court then said that we also have to look at the phrase foreign nation or government in the context of the AEA to see if it applies or if it's applicable in this case. So again, very methodical in the way that the majority walks through this. So in the end, they look at the fact that the AEA has only been invoked 3 times prior to convicted felon Donald Trump doing it earlier this year. 2 times occurred after, and the other occurred just days before Congress declared war on nations covered by that AEA invocation. It was after war was declared in 1812 against Great Britain, after war was declared against Germany in 1917, and just before war was declared against the Axis powers in 1941. So if you think about it, in the historical context, the AEA clearly lives in the space of war and a war declaration. But then again, the statute goes on and allows for, the president to be able to do this if there is a predatory incursion or an invasion. And so this majority opinion just walks through the history. And when I tell you it's actually really fascinating, I urge you to go and read this because it actually was a very interesting deep dive into the history. So the court says just because Trump says without any facts that there's been an invasion or a predatory incursion, that's not sufficient. They say that will not suffice. You actually have to have more meat on the bone, and we're not going to just take that declaration by the president for what he says it is. We define an invasion for purposes of the AEA as an act of war involving the entry into this country by a military force of, or at least directed by, another country or nation with a hostile intent. So, the proclamation by Trump, according to the court, does not find support in the idea that there has been an invasion for purposes of the invocation of this statute. So now we know there's no declared war, and now we know that there's no invasion. As defined by traditional definitions, legal definitions, there's no invasion. So what's the next area? Predatory incursion. This is what the court said. Based on the dictionary definitions and neighboring statutory text, a predatory incursion, as used in the AEA, definitely applies to an unauthorized entrance by units of another nation's military to commit acts that are destructive to the interests of the United States, such as victimizing its people or property, for the benefit of a foreign power or its agents without the necessary objective of a long-term occupation or control of American territory. Again, makes sense, right? Unauthorized entrance by units of another nation's military. That sounds like a predatory incursion, right? Same with the definition of invasion. This idea that it's got to be an act of war, right? Even if you don't have declared war, it's got to be something that invokes this idea of the military to be able to travel under the AEA. And again, I'm just going to fast forward to this because I don't want to, spend too much time in the weeds, but these were really kind of important points that I wanted to bring to your attention about this. A country's encouragement of its citizens and its residents to enter our country illegally is not the modern-day equivalent of sending an armed, organized force to occupy, disrupt, or otherwise harm the United States. There is no finding on the record that this mass immigration was an armed, organized force or forces. It's an action that would have been possible when the AEA was written, and the AEA would not have covered it even then. And so the AEA does not apply today either when it comes to the idea of Tren de Aragua, TDA, as a gang in Venezuela, being this thing that's being controlled by the Maduro regime to raid the United States with all of these, quote, illegal immigrants that are coming here. The court says, nope, sorry, we're not buying that. I also thought this is important to highlight The court on page 33 says, we have already held that factual assertions by the president are to be accepted, but freestanding labels to unstated actions are not relevant findings. So, for example, they say, yeah, even if there is drug trafficking, that is not, and even if the drug trafficking is being used as a weapon, that is not even close to being within the updated meaning of an invasion or a predatory incursion. Okay? So, now that we know that this court says that there is no declared war, there's no invasion, there's no predatory incursion, we therefore conclude, page 35, that the petitioners, the immigrants in this case, they are likely to prove that the Alien Enemies Act was improperly invoked by felon Trump. They didn't say felon Trump, I said felon Trump. So now, where do we go? So now we actually have this, okay? And by the way, I just want to sit there and drop a note that, as you know, I work with Democracy Defenders Fund with my great friend, colleague, Norm Eisen. And there's actually a hat tip to DDF here in the opinion. And it notes that our amicus brief was well taken in a great way. So I'm very proud of that. Okay, so this opinion underscores, though, that the government may continue to try to remove the petitioners and others under other lawful authorities, but it can't be because of Trump's invocation of the AEA. That is made explicitly clear at this point. And we know that that AEA concept, this idea that these are Tren de Aragua gang members, I mean, this is the Kilmar Abrego Garcia case, right? We know that that is being used as the boogeyman to be able to sweep people up, regardless of who they are, and just summarily get them off of U.S. soil. The last component of this is, do you get enough notice based upon what the government is telling you in your removal proceedings? And this is a very kind of quick analysis that I want to get to here. Under the updated notice, okay, so the original notice was woefully inadequate. And while all this litigation was pending, the United States government got smarter and they provided an updated, amended notice to petitioners and immigrants. So now here's what it says. The government now gives detainees pursuant to the Alien Enemies Act, right, notice of their detention in a language that they understand, because God forbid you actually have something that materially affects them, it impacts them in such a way that it wouldn't be in the language that they would understand. So now the notice is in the language that they understand. It provides information about how they can challenge their detention, including how they can contact counsel, because again, that's your opportunity to be heard, right? Notice, opportunity to be heard. That includes the opportunity to get counsel, because this is not an easy space to navigate at all, right? And you have 7 days as a detainee in which to file your habeas petition before you're being removed. Okay, so let's reiterate this. You now have notice in a language that you understand if you're a detainee. You are given information on how to challenge your detention and how to get a lawyer to help you challenge the detention. And you're given 7 days to be able to file your habeas petition. Now, by the way, there is a partial dissent here that says 7 days is still not enough. 21 days, for example, would be better. And I agree, by the way. Immigration law and the immigration proceedings are already so murky and so hard to navigate. I can't imagine trying to do this otherwise without help and in such a rushed period of time, right? Okay. So in the end, the majority says, we stress that our holding here is based on the current record, and it's undeveloped because there hasn't really been fact-finding in this case. Because remember I said how it really fast-tracked the Supreme Court so fast. So we're granting this preliminary injunction. We're blocking the removal of the petitioners. We're leaving in place the latest version of the government's notice to detainees that you and I just walked through right now. And we're remanding, meaning we're sending it to the trial court for further proceedings. And right now the government can move forward with trying to remove the petitioners and even people that are presumptively a part of a class that hasn't been certified yet in this case, assuming that they have lawful authority to do so. And listen, again, I thought this was such an important case for us to go through, and I would love to be able to do a deeper dive with you, because this is, again, a huge landmark decision that we're getting concerning Trump's invocation of the Alien Enemies Act. And I also like it because we know that he's been using pretext as a tool to be able to do a lot of illegal things. And so when we know that that is proven to be false, then that empowers us, right? Because we now know that judges are adhering to the rule of law and they're being conservative in the way that they're interpreting things. And even in their conservative interpretation of statutes, it's still showing that Trump is losing. Be mad, be outraged, demand account. We're paying attention to the Texas gerrymandering. We're paying attention to the tariffs. We're paying attention to the Epstein files and the latest in the Ghislaine Maxwell debacle. But we're also paying attention here at the Katie Phang News Channel to Alligator Alcatraz and the latest developments there. Not only the legal developments, but just the human developments there. Or maybe it's the lack of humanity. Partially because Alligator Alcatraz is being held up and touted by the Trump administration and Kristi Noem at the Department of Homeland Security as kind of the gold standard to be able to emulate and to replicate in other places like Arizona, Nebraska, Louisiana. We know that Fort Bliss in Texas is already being used to detain immigrants. We also know that Governor Greg Abbott has pledged to build the largest immigrant detention facility in the Trump administration. It is a race to the bottom for these people. They have no souls. They are soulless ghouls. But even just yesterday, Kristi Noem announcing the quote, Speedway Slammer in Indiana. The capabilities of holding 1,000 detainees at a maximum security prison. I want you to stop for a second and think about this. Ghislaine Maxwell, convicted child sex predator, convicted child sex trafficker, convicted child sex abuser. She's not even at a maximum security prison. In fact, she got special dispensation to go to a minimum security camp where you could just walk off. You can go on work release. But more than 70% of the immigrants that are currently in custody, in detention, courtesy of the Trump administration, they have no criminal history. But we're going to put them at a maximum security prison in Indiana because Kristi Noem wants to be able to call it in a cutesy way, in a kitschy way, quote, the Speedway Slammer. It's disgusting, the dehumanization of people. We know that there's an Alligator Alcatraz hunger strike right now because of the inhumane conditions at that facility. It's a concentration camp, people. It meets all the definitions of a concentration camp. And we have people that are being shipped out in ambulances because of the hunger strike and because of the conditions there. And just yesterday, the local NBC affiliate, NBC6 here in South Florida, it had a former corrections officer who was working at Alligator Alcatraz. Her name is Lindsay. I want you to take a listen right now to the way that she describes the conditions at Alligator Alcatraz. She witnessed them firsthand. She experienced them firsthand. She lived them firsthand. But I want you to listen very carefully to the way that she describes the conditions for the detainees that are at Alligator Alcatraz. Take a listen.
While Lindsay knew she was going to be living in a shared trailer, she says the conditions were rough for everyone there.
We had to use the porta-johns. We didn't have hot water half the time. Our bathrooms were backed up.
Shut it down! Shut it down! NBC6 has reported similar accounts from advocates, detainees, and their families.
It looked like an oversized dog kennel.
She says each tent had 8 large cages.
Each pod holds 35 to 38 inmates. They have bunk beds in them.
Do the math, and that means each tent holds close to 300 detainees.
They have no sunlight. There's no clock in there. They don't even know what time of the day it is. They shower every other day or every 4 days. The bathrooms are backed up because you got so many people using them.
On rainy days, she says, the water pours into the tents. She described the conditions as miserable, not to forget the constant battle with mosquitoes.
Not everybody there is a criminal.
NBC6 News has asked the state for a list of detainees at Alligator Alcatraz, but has not received it. Last month, a Human Rights Watch report found nearly 72% of people detained had no criminal history.
These people are still human. You pulled them from their livelihood. They're scared. They don't speak our language.
Detainees being held in large dog kennels, 300 detainees per tent, no sunlight, backed up toilets, urine and feces on the floor, flooding from the rain, which is, by the way, normal. Summer rain, summer storms in South Florida, they're like tsunamis. They are like torrential downpours, and that's normal. And there's that kind of flooding. I mean, I could go on, but you heard from Lindsay. You heard how she described what's happening at Alligator Alcatraz. So what's being done? As I sit here today, there is a continued court hearing that is happening in federal court in Miami in the Southern District of Florida. It is one of 2 lawsuits that have been brought concerning Alligator Alcatraz. The one that is going on right now is before a federal judge by the name of Kathleen Williams. She's the former federal public defender in the Southern District of Florida. If you recognize her name, I covered her and her courage and her defense of the rule of law when I was talking about how she held in contempt the current Florida Attorney General, James Utmeyer, for his failure to abide by a court order concerning an immigration law in the state of Florida that was deemed to be unconstitutional. So Judge Williams right now is conducting a second day of a hearing. And which lawsuit is it? It's the one that I've also covered. It is the one that is being brought by the environmental organizations. And specifically, it is being brought by the Friends of the Everglades and the Center for Biological Diversity. That lawsuit was filed on June 27th. If you also follow me on Substack, I did a Substack live with the lawyer, one of the lawyers that represents the Friends of the Everglades. That lawsuit is the fact that prior to the construction of Alligator Alcatraz, the state of Florida failed to obtain, as well as the federal government, frankly, failed to obtain the requisite pass to be able to do so because there's existing federal environmental laws that require you to determine the impact on the environment before you are going to build something like Alligator Alcatraz. Because it's in the middle of the Big Cypress National Preserve. It's in the middle of the Everglades. And there's all sorts of ecological harm, biological diversity harm that could happen. And so that's the reason why you need to make sure that you do the necessary studies, none of which were done. It was just erected kind of, in the dead of night. Now, according to the state of Florida, they're saying that because this concentration camp is a state-run facility, the federal regulations regarding the environment do not apply. But here's where it gets very kind of wonky. And just like in the other lawsuit that I'm going to talk about in a second, which was brought by the ACLU on behalf of the detainees because they can't get contact with their lawyers, the Judge Williams, has been saying, okay, this is a state facility, but it has federal immigration detainees. You'll remember, we've talked about this. When you have federal immigration law, that trumps anything dealing with state stuff when it deals with these immigrants. And so here's the confusion. You have a state-run facility run by the Florida Department of Emergency Management. And remember, it's $450 million in Florida state funds that are being used to construct and implement and run this concentration camp. But it's holding federal immigration detainees. And every time a judge like Judge Williams is asking, well, show me the agreement. What's this agreement buying between the state of Florida and the Trump administration as the federal government that dictates who does what, who runs what, whose authority is being applied to be able to do this facility? And it's crickets. There's no production of documents. There's no explanation that's being given. And so these environmental groups that are suing are saying, Judge, we need this clarity. We need to know what the hell is going on here, because according to the defendants, they're saying, oh, no, we don't have to deal with federal laws dealing with the environment because we're not a federal run facility. They're playing fast and loose. And the judge isn't stupid here. She smells the bullshit and then she's sussing it out for what it is. But still, this is a part of the legal process that is happening. So the reason why there's another day of a hearing today is the judges continue to take testimony about this because these environmental groups are seeking a preliminary injunction. They want the cessation of continued construction and running of things at the concentration camp called Alligator Alcatraz. There's also an argument that's being raised by the state of Florida. They're saying that the lawsuit shouldn't have been brought in the Southern District of Florida, that it actually should have been brought in the Middle District of Florida. So let's take a second here. The state of Florida is divvied up into the Northern District, the Middle, and the Southern for purposes of federal court. And this area called Alligator Alcatraz, it's dealing with an airstrip, right? And a portion of that area is in Miami-Dade County, and a portion of that airstrip is in Collier County. Miami-Dade County would be in the Southern District of Florida. Collier County would be in the Middle District of Florida. So the defendants in the environmental lawsuit are trying to play fast and loose when it comes to venue. They're saying, you can't sue us here in the Southern District of Florida. We need to be in the Middle District. Well, and that's, of course, what do we know? They're judge shopping too, right? They don't want to be in front of Judge Williams, who's already busted their balls in other ways about other things. And so that's part of the arguments that are being addressed in the hearing that's going on. There's also that second lawsuit that we're going to get into in a second here, but I want to make sure that we understand kind of the entirety of the legal issues from this environmental lawsuit. So there's also the pursuit in that environmental lawsuit of not only the cessation of that, but the requirement that the state of Florida and the federal government make sure that they've not only complied with all of the federal regs that they have to do, but that they're also complying with any necessary state things. And there's also a big question as to whether or not the invocation of all of these emergency powers makes sense. The fact that the governor claims that because there's a state of emergency due to, quote, illegal immigration, that he's allowed to invoke his emergency powers to be able to do the things that he's doing right now with this concentration camp. But the biggest question that's going on is, what is the relationship? Where's the legal agreement that exists between the state and the federal government to allow this to even take place in the first place? Now, after that environmental lawsuit was filed, we then got a second lawsuit that was done. And this was filed on July 16th. And this was a lawsuit brought by the ACLU and other plaintiffs. And this lawsuit was saying the following. There's a whole bunch of people that are being detained at that concentration camp, and they have zero opportunity to be able to meet with their lawyers. It is a black box at Alligator Alcatraz. Black box of information, black box of contact. And we don't know, as the lawyers, the immigration lawyers, where are we supposed to be filing motions for bond hearings? Where are we supposed to be filing petitions to be able to get in front of courts? Because every time these lawyers have tried to do this, they're told, no, talk to the federal government. No, talk to the state. We have nothing to do with it. But it's intentional, right? I mean, it kind of makes you wonder. It's either a really egregious Keystone Cops moment where they truly are so dumb that they don't know who's doing what. It's like a who's on first moment, but in a really tragic way. Or they are trying to pretend to be ignorant about it so that they can just punt responsibility back and forth until eventually this happens. You end up in court and you get another good judge who says, no, I need to see what is going on here. So that second lawsuit involving the ACLU was in front of another federal judge in the Southern District of Florida. His name is Rodolfo Ruiz. He keeps on asking the government's attorney who has legal authority over Alligator Alcatraz. And at the last hearing, just a couple of weeks ago, this is what the answer was. Quote, I'm not prepared to say what our position is. We have an idea, but I need to confirm it. I want to take a small point of personal privilege here. I would be humiliated as a lawyer to go to court and I would tell a federal judge of all people that I don't have the answer. Now, it's one thing to say, I'm not familiar with this legal concept or whatever, but when a judge asks you a basic fundamental question about the existing legal relationship on who is running a concentration camp in the middle of the Everglades that is causing this much national, international attention, you mean to tell me as the lawyer for the government, you can't answer that question? I think the answer is you can answer that question. You're just choosing not to, which means you are just as complicit as the lawyer, as the client, as the person that you're representing, as the agency that you're representing. You are what I call an enabler. And the enablers as the lawyers are just as bad as the bad actors that they're representing. Just as bad. So, Judge Ruiz ordered by today, in his case, he wanted to make sure that he got a look at what is called the 287G agreements between Florida and the federal government. 287G agreements are the ones that are the cooperation and the assistance that is provided by the state and local and municipal organizations or jurisdictions, to the federal government to help them in their immigration efforts. And in Florida, and I'm going to do a really detailed Substack on this written, and then I'll do an accompanying video here on YouTube to walk through it. But essentially, Florida, because it's being run by DeSantis, it obviously has an incredibly stringent and draconian view of the 287Gs. But these 287G agreements should be executed, and they should be the things that are driving that relationship between the state, local, and municipal jurisdictions, law enforcement, et cetera, agencies, and the federal government. And yet, mysteriously, we still don't see a 287G agreement concerning Alligator Alcatraz. So, the judge, Ruiz, keeps on asking, who is running this facility? Quote, who is running the show? And there is no response that is clear that is being given by the state of Florida, even really from the federal government. So the next in-person court hearing for the ACLU lawsuit is coming up on August 18th. But I want to just underscore, you have the environmental lawsuit, and then this ACLU lawsuit deals with the fact that more than 100-something detainees have already been deported already from Alligator Alcatraz. No contact with their lawyers, no bond hearings, no ability to file bond petitions. And so the lawsuit alleges a violation of the First Amendment rights and the due process rights of these detainees that are a part of this lawsuit that was filed by the ACLU. The ACLU is also seeking class certification, that class action, the certification of an entire class to be able to continue in its litigation against the federal government. I appreciate how y'all want to continue to know about this, because I read your comments, I hear from you, and I'm always concerned about whether there is something of value that I am providing to you in these videos that we're doing. And the reason why I take the time to be able to do this is I want you to understand that there are so many nuanced things going on in court that run the gamut from just who the judge is that gets the assigned case, to the lawyers that are representing the parties, to the issues, to the public pressure campaigns, to just kind of the procedural status of these cases. They seem to move so slowly, and I get it. And sometimes the wheels of justice grind slowly. But this is where a lot of the battles are being fought right now, and that's in court, which is why we can't have a defeatist or a fatalist attitude about us going to court and maybe, not having compliance or not having the right thing done. We need to continue to use the judicial system as an institution, as a place where the rule of law is supposed to exist. We have to continue to use our judicial system for its purpose. And I'm biased because I'm a lawyer. I'm a trial lawyer. I'm somebody who goes to court, and I do these battles in court. But it's this opportunity to be able to force the Trump administration to have to own up to what is happening here. And I do think everything was so hastily done at this concentration camp that they really don't know they don't really know, but that's not a fucking excuse. Okay? It's not an excuse. The incompetence of the Trump administration and the incompetence and stupidity of Kristi Noem, footnote, if you haven't seen the South Park episode about her, you just run and go watch it. But the incompetence and the stupidity collectively of the Trump administration, Kristi Noem and others, is not an excuse to violate the due process rights of immigrants. And it's certainly not an excuse to be able to put those immigrants whose due process rights are being violated in inhumane conditions at a concentration camp in the middle of the Everglades. And it is certainly not an excuse to hide behind your incompetence and your stupidity to evade accountability in court, especially when federal judges are pressing you to answer the questions as to who in the hell is running the show at Alligator Alcatraz. So my hat off to not only the ACLU, but lawyers like Scott Hyacin in that environmental case for the Friends of the Everglades. These are people that are saying, not on my watch. We're not going to stand by idly and watch our United States Constitution get destroyed by people like Kristi Noem. So I'm going to report back to you guys once I know the details of what happens, not only in the continued hearing for the environmental impact case, but also what happens today with some of the filings that are going to happen in the ACLU case about who is really having the authority to run and operate and to deal with the concentration camp called Alligator Alcatraz. What does A Light in the Attic by Shel Silverstein? The Complete Book of Cats, The Complete Book of Dogs, Mouse, M-A-U-S, Calvin and Hobbes. What do any of those books have in common? Well, I'll clue you in. They have now all been banned in several counties in the state of Tennessee, and for stupid, god-awful reasons. And it's just ridiculous. I mean, we've talked about book banning before, and this is nothing new to you guys, but when you see something like, quote, The Complete Book of Cats being banned from a school, you know that there's seriously something that is wrong. So here's what's happening. In Monroe County, Tennessee, 574 books have been purged from their school libraries. In Knox County, more than 100 titles have been removed. More than 150 titles removed in Rutherford County. Over 300 books are banned in Oak Ridge schools, and over 400 titles have been removed in Wilson County. And that does not even account for every county in the state of Tennessee that has been impacted. All of this information has been provided gratefully by PEN America. If you're not familiar with PEN America, I urge you to go and check out their website. Their website is fantastic. And the reason why you need to go check out PEN America's website, and it's www.pen.org, is PEN America is at the forefront of the fight for the First Amendment to protect free expression in the United States and globally. And PEN America actually is an organization that several authors and writers are a part of because they also believe in the importance of the First Amendment and your freedom of expression. But what's wild about this Tennessee county ban is it is so indiscriminate. And listen, as you guys know, I'm from Florida, and Florida has one of the worst book bans in the country. So yes, Florida likes to say, hold my beer often to states like Texas and Tennessee. But Tennessee just goes to show exactly how completely indiscriminate and illogical their book ban is. So I'm going to read you, in 2024, the state legislature amended a state statute. It's entitled, quote, Age Appropriate Materials Act of 2022. And it specifies that any materials, quote, in whole or in part, that contain any nudity or descriptions or depictions of sexual excitement, sexual conduct, excess violence, or sadomasochistic abuse are inappropriate for all students and do not belong in a school library. So what does this mean, though? One, it means that you don't actually evaluate the text as a whole. They're only looking at certain portions of the text. And isn't that freaking convenient, right? It's convenient because if you're trying to apply an overly broad, vague, and unconstitutional statute, of course, this is a convenient way to craft the language of the statute, because then pretty much anything and everything, including the Complete Book of Cats and the Complete Book of Dogs, is going to fall within the purview of that. I'm not sure how, because it's just crazy, right? So what they're doing is these schools are taking just excerpts of books without context as a whole, and they're using it as a justification underneath this Tennessee statute to be able to remove books from school library shelves. So as I mentioned, Shel Silverstein's Light in the Attic, one of my kids' favorites, that's been banned. They Called Us Enemy by George Takei. That's also been banned. Hidden Figures, The American Dream, and the Untold Story of the Black Women Mathematicians Who Helped Win the Space Race by Margot Lee Shetterly. Gone, jettisoned off of school shelves in Tennessee. As of May of 2025, according to PEN America, at least 15 states, including Tennessee, have enacted laws facilitating the censorship of school library collections by expanding the definitions of terms like sexually explicit, obscene, and harmful to minors, requiring school districts to apply such terms in new ways or risk civil or criminal liability for materials with sexual content. The fear is the intention by them, right? If they intimidate you or they make you scared into submission, same type of shit we're seeing with these immigration raids, right? If they scare you into submission, same thing with abortions, right? I mean, this idea that if you don't interpret the law correctly, you could be facing civil or even criminal liability. What are you going to do? You're going to err on the side of caution, right? Especially if you're a school. Now, in Oak Ridge, which is an area in Tennessee, they actually had a book by a guy by the name of Richard Jolly, Jolley. The book was entitled Richard Jolly, Sculptor of Glass, a collection of works by the artist. Now get this. Richard graduated from Oak Ridge High School. He's an alumnus of Oak Ridge High School, and they don't even have his book on their shelves. Why? Because an Oak Ridge school spokeswoman told local news, quote, unfortunately, as an artist, Mr. Jolly's book features depictions of the human body that are in direct violation of the law. But you also, in these public school libraries, cannot read Harper Lee's To Kill a Mockingbird or John Steinbeck's The Grapes of Wrath. Mouse, The Hidden Children of the Holocaust by Esther Mustanowitz is gone. And The Secret Holocaust Diaries by Nona Bannister, also gone. I mean, what's left? I bet you the Bible. I bet you the Bible is left on the shelves in Tennessee. The Bible with its incredibly graphic depictions of sodomy, murder, sex, infanticide, patricide, matricide, every type of homicide you could think of, every type of discrimination you can think of, sexual conduct you could think of, it's in the Bible. But the Bible's okay. Why? Because when you're a white Christian nationalist, you don't got a problem with your Bible staying on the bookshelves. But God forbid we learn about the Holocaust, or God forbid we learn about the celebrations of Black women, or God forbid we learn about dogs and cats. You would laugh if it didn't make you cry with the level of absurdity that is happening with this, right? And I want to know who is asking these officials in Tennessee, please provide what is so wrong about the book, the complete book of dogs and the complete book of cats. If it's ridiculous, it is. Let's talk about a lawsuit though. So PEN America in April of this year, just a couple of months ago, joined 3 students in Tennessee and their parents as plaintiffs in a federal lawsuit that was brought in the Rutherford County against the Rutherford County Board of Education. This is in Tennessee. This lawsuit challenges the book removals that happened in that county as well as restrictions. And this lawsuit alleges that these restrictions violate the First Amendment right of students to receive information and of the authors to express freely their opinions, their points of view, their perspectives, their art, right? The lawsuit alleges that the First Amendment has been violated because these books have been removed as a result of a Rutherford Board of Education policy banning sexually explicit books. The Board of Education removed or restricted more than 145 titles. And then this is utterly disgusting yet fascinating part about the lawsuit. So the school board, you know what the school board did? Again, the school board didn't actually go through and have them go through each and every one of the books and read them and understand the context of the books, the historical significance, the cultural importance. None of that, right, came into play. Ready? The Rutherford Board of Education relied on reviews from Book Looks, a now defunct website developed by individuals associated with Moms for Liberty. Book Looks provided ratings for books, penalizing them as inappropriate if they contain, among other things, references to gender identity and sexual orientation, or so-called inflammatory, and that I put that in quotes, rhetoric about race. So yeah, you can't even have books about gender identity, sexual orientation. It is the literal whitewashing of history that's happening. And now it's the continued, frankly, whitewashing of education. Education in schools. I mean, that's the real irony here, right? That this book banning is happening in our schools where our kids are going to get an education. And the education doesn't have to be narrowly only down the path of what white Christian nationalists think is an education. An education includes different points of view, different expressions, different speeches, different, opinions about different people of different colors and different races and different religions and different genders. It is the literal melting pot of ideas from which our children learn. And the fact that you can't get access to books anymore like this in a public school. You may be able to get it in private school, I think. But so what does that mean? So if I can't afford for my child to go to private school, does that mean that my child will then now only have access to books that Moms for Liberty thinks are the kind of books that my child should have access to? Well, I don't want that. And what's wild is, by the way, The Bluest Eye by Toni Morrison, Fahrenheit 451 by Ray Bradbury. Do you guys remember that book? I mean, it's literally this, right? It's the criminalization of being able to actually own a book, physical book, read a physical book. There's only certain books that are countenanced or approved to be able to be read. I mean, this is the agenda. This is a Project 2025 policy. It's a pillar of Project 2025. The idea that you narrowly construe what constitute knowledge and information only through the lens of the white Christian nationalists. And it is no coincidence that these laws are being passed in red states with Republican-led legislatures. It's the Republicans, people. Don't let anybody ever tell you that it's anybody other than the GOP and the Republicans, because that would be a lie. That would be a lie. I want to urge you to support PEN America. I'm not getting paid by PEN America in any way, but I am an advocate. I'm an advocate of PEN America. We need an organization like PEN America to be able to fight for everyone's right to the First Amendment. Everyone's right. They're not saying that it's just for Democrats. They're not saying it's just for public school children. They're not saying it's just for, brown people, Asian people. They're saying that children should have the right to be able to get their information from a different set of books and sources and material. And authors should have the right of free expression in the way that they write their books, present their books, and create their books. And here's the other thing. Nobody is saying that what you do in the privacy of your home is going to be regulated. And yet, I feel like we're on the verge of that. I feel like we're on the verge of having the Trump administration come and knock on your door and go through your library of books at home, go through your iPads and your laptops and your computers to see what type of content you have. Because God forbid your child is learning about the Holocaust. For an administration that is so fucking hot to trot about combating anti-Semitism, which I am a proponent of combating anti-Semitism, they certainly are quick to make sure that you don't learn about the Holocaust. The wholesale genocide and extermination of the Jews. Can't learn about it, but let's use the anti-Semitism banner to be able to do all sorts of stuff, including under the premise of immigration enforcement. The hypocrisy is rich. We have these conversations here at the Katie Phang News Channel because, again, book bans may not be new to you, but they're still happening, and they're happening at a disturbing and alarming pace. And we have to always remember that we can walk and chew gum at the same time. We can focus on things like bombings in Iran. We can focus on the decimation of our federal agencies. We can talk about the big bullshit bill, but we can also remind ourselves that book bans are wrong and they're unconstitutional. Be mad, be outraged, demand accountability, and go out and read the complete book of cats, the complete book of dogs, The Bluest Eye by Toni Morrison. Just go out and read. Read, people. Get an education. I'll see you on the other side.